Well, good morning, and it's time now for 4CRB's Finance Forum, and that means it's a very good morning to John Fradgley from the Bell Legal Group. Good morning, John.
Yeah, good morning, Colin, but we're not doing Finance Forum this morning.
We're
We're actually going to do the law and you.
My most profound apologies to all the listeners. I just was talking to Josh Mashman this morning, and I must have had him top of mind. It is the law and you.
Yes, there we go. So, and as you rightly point out, Colin, if you have any questions or queries in relation to financial matters, you should call Finance Forum on Thursday morning at the same time. But this morning is the law and you. It's your opportunity to get free legal advice between now and 9:30. The only thing you need to do is get on that telephone, 55208888. That number again, 55208888. Don't forget you can send us queries by email if you wish to talkback@4crb.com. But we do ask that you send those emails in the week preceding the program, as unfortunately we can't sort of read the emails and deal with them on air at the same time, because sometimes it takes a little bit too long to read the email, and of course we don't want dead air there while we're reading through the questions and having people wait. So if you could do that, that would be very useful. Thank you to the people who called in last week. Certainly some interesting calls and a great program. Hope it was helpful to others who were listening as well, not just to those who called. Colin, if you can just let me know when we have any callers online. I do have a few things that I was going to talk about in the lead up to that, but just a reminder, that telephone number, 55208888. The number again, 55208888.
And John,
just the Tweed River 07 in front.
And John, we do have a couple of callers lined up early, so
all right. Well, let's get into it.
Okay. Well, I'll introduce you now to George.
George, g'day, George. How are you today?
Oh, hello, John. I'm just calling on behalf of a lady friend of mine. And she just recently entered into a de facto relationship with this fellow, and he's moved into her house. And she just wants to know. She's been down that road before with relationships, and she just wants to protect her house that he's moved into that belongs to her, and he doesn't have a property, but he does do a lot around the house, and she says he's a godsend for, she needed a man around the house, and he does a lot of stuff to improve, but she still wants to know if it goes belly up, what she should do before.
Right, so, George, how long ago did this fellow move in?
Oh, very recently. Just weeks.
Okay. All right. Well, the first thing to know is that they're not deemed to be in a de facto relationship until they've been living together, basically as husband and wife, for a period of 2 years. So it's not automatically deemed a de facto relationship just because they're living together. So that's the first thing to bear in mind.
So that's 2 years.
Yes, 2 years. The only exception to that is that if there's a child born of the relationship or a child conceived of the relationship, then that doesn't apply. But, the other. Sorry, what was that, George? I just missed it.
They both have adult children from previous.
Oh, right. Okay, so there's no likelihood of children. Okay,
very unlikely.
Yeah. So look, what I would suggest your friend does is just talk to her new partner about her concerns and indicate to him that she would like to put in place a binding financial agreement that just clearly articulates the fact of what they're each bringing to the relationship, and so that there is a clear record of who owns what and what the expectations are at the end of the relationship. Now, unfortunately, George, those agreements are not cheap. to have done, but it's basically like an insurance policy. So, a lot of people just sign up agreements between themselves. They're all fine as long as no one challenges them. But if anyone decides that they're going to challenge them, they're not worth the paper they're written on, because unless the agreement is done strictly in accordance with legal requirements, they are basically unenforceable. So we would be well advised to look at getting that form of agreement in place. And I would suggest that it is better to get it in place sooner than later, because the longer the relationship goes on and the closer you get to that 2-year mark, the more difficult it's going to be for her to say, well, if you're not prepared to sign that agreement, the relationship has to end, because she'll become more and more emotionally dependent upon this fellow. So it's a lot easier to end the relationship earlier than later. So I would suggest she has that conversation now and then gets on the road to getting an agreement in place.
So, John, in the 2 years, does it take 2 years before it's actually recognised as a de facto relationship, is it? Yes, unless there's a child born of the relationship. No, it's unlikely there'll be a child, but if it goes belly up in that 2 years, is it basically nothing, as if nothing happened? Like one hasn't got a claim against the other if it's in that 2 years?
No, that's right.
Okay, I didn't know that. No, this fellow's got a few assets. He's not exactly, he just hasn't got a property. He's not doing too bad for himself otherwise, but he just hasn't got a property, and she's worried about her property, Yeah, so that was very, very good information, John. I didn't realise that, but I'll definitely tell her that, and I appreciate your help. Thanks very much.
No trouble at all. And the time on 4CRB is moving along. It's just come up to 12 minutes past 9. The Law and You is the program, 55208888, the number. And Colin, you said we have another caller online.
We've got 3 lined up for you, John, so it's going to be a busy morning.
Okay.
So I'm going to John. I'll introduce you to John.
Good morning, John. How are you today?
John, just in that recent conversation there, if I've actually gotten married, my son's living with a woman who's got three children from her marriage. They're not his kids at all. And he got himself a piece of paper to say he was married to the woman. Where's the situation in regards to his estate from me and covering his rear end? So she came in with nothing. She came in with 3 kids. I'd call it a meal ticket marriage, if you know what I mean. Just to support the situation.
So, John, they are actually married now, are they?
Yes, they are, John. Yes. So, what's his situation in regards to my estate when I die, and her claim on it?
Right. Well, if they're married, she wouldn't have any claim on your estate. But if you leave things to your son, then obviously there's a strong likelihood that he will in turn leave them to her under his will, or alternatively that if he predeceases you, that it would go, it could potentially go to the children as his stepchildren if they were married at the time he passed away. So, John, I think it's more a case of you covering your situation. And I think the best idea would be for you to make a will whereby the share of your estate that you want to benefit your son goes to him through a testamentary discretionary trust, because that way the assets are protected against any claim by his partner. And if it's structured correctly, it would be extremely difficult for his partner to get any part of those assets in the event of a breakdown of the marriage. They would still be regarded as a financial resource for your son, and therefore taken into account by the family court in the event of any breakdown. But certainly, as the law currently stands, and if the trust is properly structured, the family court to date has not made any orders in relation to those types of trusts.
So it's back to the will to start with, through a testamentary trust to look. It's a meal ticket marriage, if you know what I mean, John. There's a lot of it goes on all the time, and these 50-year-old sons, they don't understand. They just want a bit of company in their later life, so they get hooked up. And these women actually go for these sort of guys that have got to quit or are going to get it down the other end. It's
all right. Well, we better just leave it there, John, because unfortunately we've got other callers waiting on the line. That I think deals with your question.
Yep.
No trouble. All the very best. And the time on 4CRB is just coming up to, or just past 16 minutes past 9. And Colin, we have another caller there.
We do. Let me introduce you to Arnold.
Arnold. G'day, Arnold. How are you today?
Good, thank you, John. We have a problem with the next door neighbour. The fence line has got about 20 palm trees, which are 16 metres high, okay, and they are going under the fence. Consequently, it is buckling the fence line now, or the boards on the fence.
Right.
I spoke to him twice, and the second time he came down with his saw, and he sawed through 2 boards to ease the problem. But the problem is still there with the root ball underneath, which is shoving upwards. Okay? How do we stand legally with these trees right against the fence line?
Right. Well, are you in Queensland or New South Wales?
We're in Queensland.
Okay. Well, look, in Queensland, there's a very good resource. Do you have access to the internet at all?
Yes.
Okay, because there's an extremely good resource there to assist in these sorts of problems where there are disputes about fences, trees, and buildings. So if you were just simply to Google fencing disputes Queensland, it'll come up with a wonderful resource there about how you can resolve these problems. There's a step-by-step guide to resolving tree and fence disputes and what you can do in those situations. But basically, Arnold, the end of the line is to bring an application before the Queensland Civil and Administrative Tribunal, which is quite inexpensive to do. They don't allow lawyers, and you can do it yourself. And the matter is then heard before one of the members of the tribunal, and they will make appropriate orders if you and the neighbour can't resolve it. But what I would suggest as the first step would be I would get out someone to take a look at the fence and give you a quote to fix up what needs to be done. And that would obviously be someone who would say, look, the problem with this fence is that the root ball of these palm trees are now way too big for this fence. The root ball is impacting on the fence. It is going to continue to impact, and the only way to resolve the issue is either, it could either be to remove the palm trees or alternatively to dig down on the neighbour's side of the fence as part of the repairs to the fence and install what's referred to as a root barrier to prevent the roots from going through to the fence. And I'm not a horticultural expert, Arnold, so, but my recollection of palm trees is that their root systems are not hugely invasive, such as a fig tree or something like that, and that if you were to cut back the if the neighbour was to cut back the root ball of all of the palms, I think they're fairly robust, and it wouldn't kill the palms, and then put down a decent root barrier, it would stop it. Alternatively, the tribunal might order that the palm trees have to come out and the fence be repaired. But I think in either circumstances, it would be your neighbour's cost to have that done, because he's the one who's caused the problem.
Okay.
So go to that website. If you just Google fencing disputes Queensland, it'll come up with a wonderful resource from the Queensland government about disputes between in relation to housing and neighbours, and it deals with all sorts of things. It deals with fencing disputes, it deals with noise complaints, all sorts of things. So it's a very good resource in your situation. It even has pro forma forms that you can use, for example, in relation to fencing work. So if you got a quote off someone as to what repairs are needed, you could then give that to the neighbour or serve that on the neighbour with a notice requiring the fencing work to be carried out. All right, then?
Okay, thank you very much, John. That's very informative.
All the very best, Arnold. And the time on 4CRB is 21 minutes past 9. Colin, any callers there?
Yes, we have Roger on the phone for you.
Okay. G'day, Roger. How are you today?
Morning, John. Trust you're well this morning.
I'm exceptionally well, and you, I hope, are the same.
Indeed I am. Listen, John, I have a reverse mortgage over my property.
Yeah.
This is probably more academic than a problem in its own right. However, and my son is the administrator of my estate.
Right.
My question is, does there have to be a fire sale to settle the mortgage the moment of my death?
The short answer to your question, Roger, is no. Obviously, it depends on the company that the reverse mortgage is held through. I do know that my understanding is that most of these companies allow a period of about 12 months to sell, and they'll even extend that time. In some companies will extend that time if there are strong reasons as to why sales shouldn't take place. For example, if the market for your particular property is very poor because of the coronavirus, then it may be possible to make submissions. But generally, you could ring the company you've got the reverse mortgage with, but generally it's 12 months from date of death the property needs to be sold.
Well, that's pleasing to know. It'll give my son the opportunity to achieve the best result, for my entire estate. Under those conditions,
no, that's exactly right. In fact, I've got one at the moment. Roger, where it's one of the major banks, and they have allowed over 2 years without taking any action. So they seem, and I think it's all dependent, of course, Roger, on the amount of equity in the property, because most of these loans are very modest against the real property value, and so therefore it's not like the bank has to, or the financier has to realise the loan immediately, otherwise they're going to go into reverse equity. Normally the loan amounts are, 20 and 30% of the real properties, of the property's value, so they're pretty safe.
All righty. Now here's another one. What about the reduction of the interest rate on these mortgages? What?
Good luck.
out of 10, how many out of 10 would you give it?
Look, I wouldn't rate your chances highly on a reduction in the interest rate, because don't forget they are not requiring any payments to be made during the term of the loan, and I think most of them are signed up at a fixed rate. But there are certain companies that I have, just thinking about that now, I have noted one company in particular that has recently notified a very small reduction in the rate. So the old story, Roger, if you don't ask, you don't receive.
Sure enough. Well done, John. Appreciate your time.
Okay. No trouble at all, Roger. All the very best. And it's just 25 minutes past 9 here on 4CRB. The Law and You is the program. Colin, any more calls at the moment?
The board is clear, John.
Excellent. Oh, well, not excellent. I would have loved there to be some more calls because obviously the more calls we take, the more people we help out there listening in our community. And just going back to a couple of things that I wanted to mention this morning, in particular, if either you or your children are in a fairly desperate position as a result of the impact of the coronavirus and you're needing some financial assistance, rather than having particularly children or grandchildren go to the loan sharks that charge, 30 to 50% interest on loans, give some consideration to the assistance that you can get from Centrelink. There is a pension loan scheme available through Centrelink if you or your partner are on a qualifying pension. So that is one type of assistance that might be worthy of consideration for you personally if you're on the pension. Alternatively, don't forget the Good Shepherd loan. They do no interest loans for coronavirus relief in particular, and they're loaning amounts of about $1,500, possibly more, and they allow 18 months for those to be repaid. And the criteria for those are wider than they are for their normal loans. So, in other words, you can borrow money through Good Shepherd loans to repay existing debts that you have, and I think these would probably be more applicable to children or grandchildren that you may have who've got themselves into a spot of bother. But that is certainly something worth considering. The number for Good Shepherd loans is 1300 770 550. That's the coronavirus relief loan. 1300 770 550. Or if you're interested in the microfinance that Good Shepherd can provide as a more general type of finance, and this is for people who might desperately need to be buying a refrigerator or something that's an essential acquisition for the home, and rather than getting a personal loan or putting it on your credit card, you could consider going through Good Shepherd loans, and their email address for their microfinance is info@gsmicrofinance.org.au. So that's info@gs, which obviously stands for Good Shepherd, microfinance.org.au. And either of those two would certainly be preferable to getting tied up in a very expensive personal loan, or alternatively one of those payday lenders where you really end up paying an arm and a leg, literally, to get some relief. The other thing I also wanted to address very quickly in the couple of minutes we've got left is the problems that many people are having getting refunds in relation to holidays that they've paid for. Many of the travel companies are endeavouring to issue credits or playing hardball. Just bear in mind that the ACCC have certainly taken a good look at this and have already taken action against certain companies. So the ACCC is always worth a look on their website if you have access to their website. Alternatively, you can call their info centre on 1300 302 502. That's 1300 302 502. And don't forget, of course, Consumer Affairs in Queensland is also able to assist with these things. I'm John Fradgley from the Bell Legal Group. It's been great to be with you this morning for another program of The Law and You. I'll look forward, of course, to being back with you again next Tuesday. But as always, until then, it's goodbye and God bless.